of the witnesses pursuant to 42-36 and ask that the court enter such an order.
All right, Attorney Durso, do you wish to be heard on that?
I don't have an objection to that. I don't see, I do see one witness that was on the witness list. The defendant's mother was on the witness list. To the extent that she becomes a potential witness in rebuttal or on defense's case in chief, I think that needs to be addressed by the court. But outside of that, I don't see any other witnesses.
Attorney Smith?
Your Honor, I understand that she is a witness on the state's witness list. The defense certainly does not have any intention to call her. I would ask that she be allowed to remain in the courtroom and not be subject to that sequestration order.
All right, so Attorney Smith, she's not on your witness list currently, correct?
That is correct.
All right, so I just go back to you, Attorney Durso. Is it possible that if in fact there are segments of the trial that you believe would cause some sort of problem with the sequestration order and having the potential witness, that being the mother, the defendant being in the courtroom, would you be able to sort of carve those out and bring that to the court's attention?
I guess I can, Your Honor. I don't necessarily, I anticipate what the evidence is going to be. However, if certain things are mentioned during the course of the trial where the defendant's mother would become a potential rebuttal witness, that would obviously be the state's concern. So for her to watch the entire trial and maybe tailor her testimony would be problematic. That's the only concern the state has at this time. Obviously, I don't know what the evidence is going to be on the defense side, but that's the state's concern.
All right, so what I'm going to do is I am going to allow the mother to stay in the courtroom. I am going to ask the state's attorney to, at any point in time, that if you feel there is testimony that would create a tailoring issue with respect to that particular potential witness on your witness list, to please bring that to the court's attention, and we'll address it at that time. All right.
Yes, Your Honor.
Thank you. And that's sufficient with you, Attorney Smith?
That is, Your Honor. Thank you.
All right. So then the court did anticipate that this would be requested. I'm just going to read through this instruction quickly so that everyone has an understanding of what this means. So I am going to go ahead and grant the motion to sequester witnesses. This is the order that is going to be in place. All witnesses, defense, and prosecution, including expert witnesses, shall be sequestered while another is giving testimony and shall be precluded from discussing testimony with any other witness. This order extends to any and all such testimony via live coverage, testimony recorded, broadcasted, displayed on any other media platform, transcribed or documented by way of any other written or photographic form. The order extends to the transmittal of testimony to a witness by any means, directly or indirectly, through a third person or entity. Upon a sequestered witness's completed testimony, the sequestered witness is allowed to observe the proceedings in person or otherwise. The sequestered witness, however, continues to remain under the court's order to not discuss or transmit their testimony by any means to any other prospective witness. Counsel shall provide notice to all prospective witnesses of this obligation under the orders to their witnesses, and also shall inform the court immediately of any known or suspected violation of the order. The intent of the court in entering this order is to impose a broad application of the rule for the purpose of preventing witnesses from tailoring their testimony to that of other witnesses and to help to ensure a fair trial in the days of digital streaming, live media coverage, and other technological advancements. So with that, the order stands. Madam Clerk, I'll give you a copy of this. Is there anything else that needs to be addressed by the court before we bring our jury in?
I don't believe so, Your Honor.
Not from the defense, Your Honor.
All right, so with that, we are ready to proceed. Madam Clerk, please bring in our jury. Good morning, ladies and gentlemen of our jury.
State will stipulate to the presence of the jury.
Defense stipulate as well, Your Honor.
All right, thank you. So members of our jury, at this point in time, I am going to ask you to pay your attention to Madam Clerk. She's going to be conducting a jury roll call and providing an oath to you. Thank you. Madam Clerk.
Ladies and gentlemen, as your names are called, please indicate your presence by answering here, rise. That you may decide this case between the state and the defendant based on the evidence given in court and on the laws of the state as explained by the judge. That you will not talk to each other about this case until instructed to do so. That you will listen to and consider what the other jurors have to say in deliberations about this case. That you will not speak to anyone else or allow anyone else to speak to you about this case. And that when you reach a decision, you will not disclose the decision until it is announced in court. So help you God, or upon penalty of perjury. If so, please stand. Thank you. You may be seated. As that if you become a member of the jury for this case, you will decide this case between the state and the defendant based on the evidence given in court and on the laws of this state as explained to you by the judge. That you will not talk to each other about this case until instructed to do so. That you will listen to and consider what the other jurors have to say in deliberations about this case. That you will not speak to anyone else or allow anyone else to speak to you about this case. And that when you reach a decision, you will not disclose the decision until it is announced in court. So help you God, or upon penalty of perjury. If so, please stand.
I do.
Thank you.
All right, thank you. Members of the jury, my remarks at this time are to generally acquaint you with some of the legal principles that will control your deliberations and give you an idea as to how this trial will proceed, how long it's expected to take, and what our daily schedule will be. You will get detailed instructions of the law at the end of the trial before you begin your deliberations. Now, I will be reading from a set of documents to ensure that I do get all of the important information that I intend to get out to you accurately. So this is a criminal case. The state has brought charges against Raul Valle as follows. In the substitute information in the Superior Court of the State of Connecticut for the Judicial District of Ansonia Milford in docket ending 418T, Part A, June of 2025, Mark R. Durso, Senior Assistant State's Attorney, accuses Raul Valle of murder and charges that in the County of Fairfield, in the City of Shelton, on or about the 14th day of May 2022, at or near 43 Laurel Glenn Drive in said city, the said Raul Valle, with intent to cause the death of one James McGrath, did stab and cause the death of the same said James McGrath in violation of Section 53A-54A, subsection A of the Connecticut General Statutes. Count 2. And said state's attorney further accuses the said Raul Valle with the crime of assault in the first degree and charges that in the County of Fairfield in the City of Shelton, on or about the 14th day of May 2022, at or near 43 Laurel Glen Drive in said city, the said Raul Valle, with intent to cause serious physical injury to one Ryan Hines, did cause serious physical injury to the said Ryan Hines with a dangerous instrument, to wit, a knife, in violation of Section 53A-59, subsection A1 of the Connecticut General Statutes. Count 3. And said state's attorney further accuses the said Raul Valle with the crime of assault in the first degree and charges that in the County of Fairfield in the City of Shelton, on or about the 14th day of May, 2022, at or near 43 Laurel Glenn Drive in said city, the said Raul Elia Valle, with intent to cause serious physical injury to one Thomas Connery Jr., did cause serious physical injury to the said Thomas Connery Jr. with a dangerous instrument, to wit, a knife, in violation of section 53A-59 subsection A1 of the Connecticut General Statutes. And count 4, said state's attorney further accuses the said Raul Elia Valle with the crime of assault in the second degree, and charges that in the county of Fairfield, in the city of Shelton, on or about the 14th day of May, 2022, at or near 43 Laurel Glenn Drive in said city, the said Raul Elia Valle, with intent to cause physical injury to one Faison Teal, did cause physical injury to the said Faison Teal with a dangerous instrument, to wit, a knife, in violation of section 53A-60 subsection A2 of the Connecticut General Statutes, dated at Milford, Connecticut, the 13th day of June, 2025, signed by Mark R. Durso, Assistant State's Attorney. Now, ladies and gentlemen of the jury, the information which I just read to you is not evidence. It is merely the formal means of accusing a person of a crime and bringing him to trial. You must not consider it as any evidence of the guilt of the defendant or draw any inference of guilt because the defendant has been arrested and formally charged. Every defendant in a criminal case is presumed to be innocent, and this presumption of innocence remains with the defendant throughout the trial, unless and until he is proved guilty beyond a reasonable doubt. The burden is on the state to prove the defendant guilty beyond a reasonable doubt, and that burden of proof never shifts throughout the trial. Unless you find at the conclusion of all the evidence that the state has proved beyond a reasonable doubt that the defendant has committed every element of an offense, you must find him not guilty of that offense. On the other hand, if you are satisfied that the evidence establishes the guilt of the defendant beyond a reasonable doubt, you should not hesitate to find him guilty. Now, the defendant may or may not testify in this case. An accused person has the option to testify or not to testify at the trial. He is under no obligation to testify. He has a constitutional right not to testify. You must draw no unfavorable inferences from the defendant's choice not to testify if the defendant chooses to not testify in this case. The procedure of the trial is as follows. After I finish this instruction, the state will present its evidence, then the defendant may present evidence. The defendant has no legal obligation to present evidence. The law does not require a defendant to prove his innocence or to produce any evidence. If the defendant does present evidence, the state may then present rebuttal evidence if it so chooses. When all the evidence has been presented to you, the lawyers will then make their arguments to you. Bear in mind, argument is not evidence. You may consider argument of counsel during your deliberations, but it is not evidence. Under our rules, the state argues first, then the defendant through counsel argues, and then the state argues a second time. But the defendant does not argue a second time. Each counsel is, however, given the same amount of time for argument. It is only the state that breaks its argument into two parts. When arguments are completed, I will then instruct you as to the law that you must apply in this case. At the conclusion of the instructions, I will send you to the jury room to begin your deliberations. That is the first time you will discuss this case with anyone. Up until that time, you will not discuss this case with anyone, not even each other. Once deliberations start, all deliberations must be conducted in the jury room and only when all jurors are present. When you deliberate, you apply the facts that you find to the law as I instruct to reach your verdict, and your verdict must be unanimous. My responsibility as judge is to conduct the trial of this case in an orderly, fair, and efficient manner, to rule on questions of law that arise during the trial, and to instruct you as to the law that applies to this case. It is your duty to accept that law as I state it to you, whether you agree with it or not. My actions during the trial in ruling on claims or objections by counsel, in comments to counsel, in questions to witnesses, or in setting forth the law in instructions to you are not to be taken by you as any indication of my opinion as to how you should determine the issues of fact. If you come to believe during the trial that I have expressed or intimated any opinion as to the facts, you should disregard it. As I've told you, my job as judge is to ensure there is a fair trial so that you can decide this case. During the course of the trial, I may occasionally ask questions of a witness. Do not assume that I hold any opinion on the matter to which my questions may relate. Remember at all times that you as jurors are at liberty to disregard all comments of the court in arriving at your own finding as to the facts in this case. You must not take anything I may say or do during the trial as indicating what I think of the evidence or what your verdict should be. Your function as the jury is to determine the facts. You are the sole and exclusive judges of the facts, and you alone determine the weight, the effect, and the value of the evidence, as well as the credibility of the witnesses. You must consider and weigh the testimony of all the witnesses who appear before you, and you alone are to determine whether to believe any witness and the extent to which any witness should be believed. It is your responsibility to resolve any conflicts in testimony that may arise during the course of the trial and to determine where the truth lies. In the course of evaluating the evidence, you are entitled to draw any and all inferences that you find reasonable and logical from the evidence you hear. You will decide what the facts are from the evidence that is presented here in this courtroom. That evidence will consist of the testimony of witnesses, documents, and any other material admitted into evidence as exhibits, and any facts on which the lawyers agree or that I may instruct you that you must accept. The following are not evidence, and you must not consider them as evidence in deciding the facts of this case. Statements and arguments by attorneys, questions and objections of the attorneys, and testimony that I instruct you to disregard. There are two kinds of evidence in a trial, direct and circumstantial. Direct evidence is testimony by a witness about what that witness personally saw or heard or did. Circumstantial evidence is indirect evidence. That is, it is evidence from which you can infer another fact. As an example, if you wake up in the morning and see that the sidewalk is wet, you may infer that it rained during the night. The wet sidewalk is circumstantial evidence that it rained. Other evidence, however, may provide another explanation for the water on the sidewalk, such as a garden hose that was left on overnight. Therefore, before you decide that a fact has been proved by circumstantial evidence, you must consider all the evidence in the light of reason, experience, and common sense. In deciding this case, you may consider both direct and circumstantial evidence. The law permits you to give equal weight to both, but it is for you to decide how much weight to give to any evidence. Now, some evidence may be admitted for a limited purpose only. When I instruct you that a piece of evidence has been admitted for a limited purpose, you must consider it only for that purpose and for no other. In deciding the facts of this case, you are the sole judges of the credibility of witnesses. You will have to decide which witnesses to believe and which witnesses not to believe. You may believe everything that a witness says or only part of it or none of it. Every witness, however, starts on an equal basis. You are to listen to all of them with an open mind and judge all of them by the same standards. Police will be testifying in this case. You must determine the credibility of police officials in the same way and by the same standards as you would evaluate the testimony of any other witness. The testimony of a police official is entitled to no special or exclusive weight merely because it comes from a police official. You should recall his or her demeanor on the stand and manner of testifying and weigh and balance it just as carefully as you would the testimony of any other witness. You should neither believe nor disbelieve the testimony of a police official merely because he or she is a police official. During the course of the trial, counsel for either party may object to a question asked by the other lawyer. It is the responsibility of counsel to object to evidence which he or she believes is not properly admissible, and you should not be prejudiced in any way against a lawyer who makes objections. When that happens, I will rule on the objection. If I sustain the objection, you will not hear an answer to the question, and you should not wonder why it was asked or speculate as to what an answer would be. If I overrule an objection, you will hear an answer to the question, and you may give it whatever consideration you feel that it is entitled to. There may be times when counsel or the court may ask that you be excused when arguments or objections are made. Those arguments often include matters or evidence that the court may eventually exclude. The reason that I ask you to step out is to assure that you will not hear evidence that is not properly admissible and not to keep you from evidence that you should hear. A few moments ago, you took an oath that will govern your conduct as jurors between the time you took the oath and the time you're discharged by me after you've rendered a verdict in this case. That oath and the rules of court obligate you to do certain things and to avoid other things. So I would like to review those obligations with you at this time. First, you must decide this case based solely on the evidence presented here in the courtroom and on the law as I explain it to you. Second, do not make up your minds about what this verdict will be until after you have heard all the evidence, heard the closing arguments of the attorneys, my instructions on the law, and after that, you've had an opportunity with your fellow jurors to discuss the evidence. Keep an open mind until that time. There are some rules that flow from these obligations. I'm going to go over those. You may not perform any investigation or research or experiments of any kind on your own, either individually or as a group. Do not consult any dictionaries for the meaning of words or any encyclopedias or the internet or any other source for general information on the subjects of this trial. Do not look anything up on the internet concerning any information about this case or any of the people involved or the locations involved, including the defendant and witnesses, the lawyers, or the judge. Do not get copies of any of the statutes that may be referred to in court. Do not go to the scenes where any of the events that are the subject of this trial took place or use the internet, maps, or Google Earth or any other program or device to search for or view any place discussed during this particular trial. You may ask yourself why. Because the parties to have this case decided based only on the evidence they know about and that which has been introduced here in court. If you do some independent research or investigation or experiment that we don't know about, then your verdict may be influenced by information that has not been tested by the oath to tell the truth and or by way of cross-examination. The same thing is true of any media report you may come across about this case or anybody connected with this case. If you do come across any reports in the newspaper, magazine, TV, internet, by way of any type of blog or social media report, you may not read, watch it, or listen to it, as it may refer to information not introduced here in court and may contain inaccurate information. If you are accidentally exposed to such information despite your best efforts to avoid it, do not discuss it with your fellow jurors and notify the clerk in writing. You may not discuss this case with anyone else, including anyone involved with this case until the trial is over and you have been discharged as jurors. Anyone else includes members of your family, your friends, and your co-workers. If you wish, you may tell them you are serving as a juror, but may not tell them anything else about the case until it is over and I have discharged you. You may not talk to any of the court personnel, including marshals, clerks, and anyone else about this case. You may not ask any friends you have who are lawyers or law enforcement personnel or medical personnel for any advice or information about any matters related to this case. You may not communicate to anyone any information about this case. This includes communication by any means, such as text messages, email, internet chat, blogs, social websites, such as Facebook, Instagram, YouTube, TikTok, or X. Both the defendant and the state are entitled to a fair trial rendered by an impartial jury, and you must conduct yourself so as to maintain the integrity of the trial process. When you have rendered a verdict and you've been dismissed by the court, at that time you will be free to discuss the case with anyone you wish, though remember, you will not be required to do so. Until then, however, you must be focused solely on the evidence presented in the courtroom and your obligations to the fairness of these proceedings. In addition, you may not talk to each other about the case until I tell you to do so. And that will not be until you've heard the evidence, you've heard the closing arguments by the attorneys, and you've heard my instructions as to the law that you are to apply to the facts that you find. Now, it may seem only natural that you would talk to each other while the case is going on. The problem with that is when people start discussing things, they take positions on them and express opinions, which are often hard for them to change later on. So if you were permitted to discuss the case while it was going on, you might reach conclusions or express opinions before you've heard all the evidence or heard the final arguments of counsel or heard the law that you must apply in this case. Your verdicts in this case might then be improperly influenced by the conclusions or opinions you or your fellow jurors have reached before you knew about all the evidence or the law that will help you put that evidence in the proper context for your verdicts. What happens if these rules are violated by a juror? Well, in some cases, violations of the rules of juror conduct have resulted in hearings after trial at which the jurors have had to testify about their conduct. In some cases, the verdict of the jury has been set aside and a new one ordered because of jury misconduct. So it is very important that you abide by these rules. If someone should attempt to talk to you, either one of your fellow jurors or someone from the outside of your jury, please report it to the clerk immediately. If you see or hear anything of a prejudicial nature or that you think might compromise the proper conduct of this trial, please report it to the clerk immediately. These communications should be in writing. Do not discuss any such matters with your fellow jurors. Now, you may, if you wish, take notes during the trial. You are not required to take notes, even if your fellow jurors do. Let me emphasize some ground rules regarding note-taking if you choose to do so. Notes are a sound tool to help you refresh your recollection during deliberations. However, notes by themselves are not foolproof. If there is a conflict between your notes and your recollection, it is your recollection that must prevail. Additionally, if there is a conflict between your recollection and the notes of a fellow juror, it is again your recollection that should prevail, as your notes are not evidence. You will recall my earlier definition of what constitutes evidence. Your verdict must be based exclusively on evidence presented at trial and the principles of law given to you in my final instructions. The note-taking process should not distract you from focusing on the witness because the credibility that you ascribe to a witness is critical. It is essential that you do not allow note-taking to interfere with or impede your ability to view the witness, to listen to him or her, and to size him or her up, that is, to properly evaluate the witness. You should not be so preoccupied with taking notes that you overlook what the witness is saying and how the witness is saying it. You may find that note-taking may distract you from giving full attention to a witness. You will need to observe the demeanor of a witness while he or she is testifying. You will be able to get testimony played back to you during your deliberations, so you do not need to make your own record of exactly what was said. There is no need to try to take a lot of notes or to take down testimony word for word. You may not make or modify any notes outside of court. Notepads will be collected at the end of each trial day and kept secure and confidential by the marshal or court officer. No one will look at them, so whatever notes you take are confidential. You are not to exchange or discuss your notes with your fellow jurors during the trial itself. You may discuss your notes if you choose during the deliberations. Just as you cannot discuss or deliberate this case among yourselves until the case has been completed, so too you cannot exchange or discuss your notes until the trial has been completed. There is no requirement, of course, that you take notes. This is an option to be exercised by each of you individually. Those of you who elect not to take notes will be no less conscientious than jurors who take notes. The juror who takes few or no notes should not permit his or her individual recollection to be influenced by a juror whose notes may differ from that recollection. Notes are only a tool, and notes are not always accurate. Do not assume that a voluminous note taker is taking notes that are necessarily more accurate. I take notes because I may be asked to rule on issues during the evidence. Your decision whether to take notes at any point should not be influenced by my note taking. Finally, notwithstanding note taking by you and your fellow jurors, do not hesitate to seek a reading of any portion of testimony back if you deem it essential during your deliberations. The lawyers have informed me that they expect the evidentiary portion of the trial to take approximately 2 weeks. However, that's only an estimate. The trial may go on longer or shorter. I will try my best to keep you informed of any changes or any adjustments to that schedule. Once the evidence is presented and the case is presented to you for deliberations, the length of the deliberations will depend on you. During the trial, and this is important, any communication you wish to make with me must be in the form of a note, which will be read to the lawyers and the parties and made a part of the record. If you have a question or a concern, write it down, give it to the marshal or court officer who will bring it to me. With these comments, I will make a brief inquiry to counsel, and then we will be attending to the evidence. Ladies and gentlemen of the jury, thank you for your attention. Counsel, do you wish to be heard regarding preliminary instructions at this time?
Nothing from the state, Your Honor.
Nothing from the defense, Your Honor.
All right, with that then, I will direct the state to please call its first witness.
Thank you, Your Honor.
Thank you.
The state would call Lonnie Blackwell to the stand.
Please watch your step. Please remain standing as you enter the witness box. Pay attention to Madam Clerk, who will be putting you under oath. Thank you.
Please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I swear.
Thank you. Please state your full name, spelling your last name for the record, as well as your badge number and business address.
Lonnie Blackwell. Last name is Blackwell. And what was
Badge number and business address.
currently I don't have a current badge number. My business address would be 150 Court Street in New Haven, Connecticut.
Thank you. You may be seated.
Good morning, Mr. Blackwell.
Good morning.
You mind just keeping your voice up? It's a little loud in here with the AC, okay?
No problem.
Can you please tell the ladies and gentlemen of the jury what you currently do for a living?
Yep. So currently I'm employed by the Department of Homeland Security. I'm awaiting to go my training to become a special agent in about 2 months. I've been employed by them for about a month. Prior to that, I was a police officer for the Shelton Police Department for about 4 years.
And when you were a police officer, did you have any training that you had to go through to become a police officer?
Yes, I attended the Milford Police Academy for about 8 months in 2021.
And I want to direct your attention to May 14th of 2022. Were you working that day for the Shelton Police Department?
Yes, I was working the evening shift, 4 p.m. to midnight.
And what were your responsibilities that night?
I was on the patrol division at the time, so I was responsible for responding to calls that were in my area that was assigned to me.
Did you receive a 911 call that night to report to an area of Shelton?
Yes, I did.
And can you tell us a little bit about that?
Yes, so around 11:53 p.m. that night, dispatch reported that there was multiple stabbing victims at the address of 43 Laurel Glenn Drive. I immediately responded to the area and arrived to the area of the scene in about 6 or 7 minutes.
Your Honor, I don't think there's an objection. We have some exhibits that have been pre-marked. Maybe asking to be made full exhibits at this time. I don't know if we're going to
All right.
No objection, Your Honor.
have they been marked full? Yeah.
Your Honor, I have reviewed these in advance.
All right, give me one moment. Once they're marked.
Your Honor, I'll do this one.
Guess what number has that one? Thank you. Thank you. Attorney Smith, you've had an opportunity to review exhibits 1 through 9.
I have, Your Honor. I'll take a chance to
Thank
go
you.
through them one more time now that we've got the numbers on them.
Thank you.
No objection, Your Honor.
All right, court will go ahead and accept into evidence states exhibits 1 through 9.
If I may approach the witness, Your Honor.
You may.
Mr. Blackwell, I'm showing you what's been marked as State's Exhibit 1 as a full exhibit. Can you tell ladies and gentlemen of the jury where you responded to in State's Exhibit 1?
Yep. So when I initially was going to the call, I turned on to Adams Drive here. and I drove up to the intersection of Laurel Glenn and Adams. When I approached Laurel Glenn, I could see from my cruiser that there was a large group of juveniles. At the time, I approximated maybe 30 juveniles right in front of the yard of 43 Laurel Glenn. And I was flagged down at the corner of Adams and Laurel by a small group of female juveniles who waved me down and started pointing me towards the direction of where the incident occurred. So I exited my cruiser at the time and began jogging over to the front yard of 43 Laurel Glen.
And just for the benefit of the record, is 43 Laurel Glen located where that red mark is on top of, in the middle of States 1?
Yes.
And when you got to the scene, what was the scene like?
It was chaotic. As you can imagine, a large group of juveniles, pandemonium. I would describe it as that. That's best.
Around what time did you arrive there?
Right around midnight.
And what were the lighting conditions out that night?
It was dark, but I could clearly see, probably due to the mix of lights on the house as well as a ton of the juveniles had phones out, lights from the phones, as well as my own flashlight, but everything I could see pretty clearly.
I want to show you State's Exhibit 2. This is marked as a full exhibit. Can you see that?
Yes.
Again, is this 43 Laurel Glen where you arrived at 12 a.m. on the 15th of May of 22?
Yes.
And is this States 2 kind of show the area, what it was like, absent the individuals on the front lawn?
Yes.
And when you got to 43 Laurel Glen on the 15th, midnight on the 15th, where did you respond? Can you tell us where you responded to in States 2?
Yes. So when I walked up on foot, I responded to this specific area of the grass area to the right of the house if you're looking at the front of the residence. And that's where a large majority of the juveniles were located, as well as the 4 victims that I later identified.
I'm going to show you States 5. This is a daylight picture that was taken, obviously, at 43 Laurel Glen.
Yes.
Okay. And the area that you responded, you see this debris area here pointing to the middle section of the grassy area where there looks like there's some clothing items located just to the right of the basketball hoop, just below the red bush area here. Is that the area that you responded to?
Yes.
Okay. And when you responded there, tell the ladies and gentlemen of the jury what you encountered at that point in time.
Yep. So a few of the juveniles pointed me to the victims. So at first, within this area on the grass to the left, I identified 2 victims. One victim had a wound to his arm. He was responsive. He was standing. He was talking. Another victim was sitting upright on the grass, and I witnessed what appeared to be a stab wound to his torso area. He was still responsive at the time. Then I moved on to the right side of the grass area, where then I identified another victim with multiple stab wounds to his leg. At that time, I saw he was bleeding a lot out of the leg, and I applied a tourniquet to his left thigh area as high as I could. And then after applying that tourniquet, I moved on to the last victim that I identified as having a wound to his chest area and began providing medical attention best I could.
With regards to the third individual that you applied a tourniquet, can you tell the ladies and the gentlemen of the jury why you did that? Yes.
So for my training in the police academy, for our medical training, we're taught if you have a wound and are bleeding a lot from an appendage and you're able to place a tourniquet, that can assist in stopping the bleeding. So that's why I placed it as high as I could on his left leg, where most of the wounds I saw were, to assist in stopping the bleeding.
And based on your training experience, based on what you saw the wounds to be like, what gave you that impression that the tourniquet was appropriate at that point in time?
First of all, because they were on an appendage, and I witnessed a large amount of blood being lost from the wounds. So I was able to apply the tourniquet due to it being on the leg.
I'm going to show you State's Exhibit 7. This is marked as a full exhibit. Again, this is the area that you responded to that night.
Yes.
Okay. And you see there's like a blue T-shirt here, what appears to be blue clothing, pointing to the middle of State 6.
Yes.
And can you tell the ladies and gentlemen of the jury, is that the area that you responded to after you applied the tourniquet to the third individual? Is that where you found the fourth individual, around that area?
Yes, in that area.
And when you found the fourth individual in that area, tell the ladies and gentlemen of the jury what you observed when you got to that person.
Yes. So when I identified the fourth victim, I immediately recognized that he was blue in the face, which was indicating to me that he probably had lost a large amount of blood. And I did locate a wound to his chest area right near the heart, and did see a lot of blood coming from that wound. So at the time, I believe some other juveniles brought out rags or cloth or some sort, maybe a T-shirt, and me as well as them, we were assisting in just compressing the wound, just trying to stop the bleeding the best we could until EMS arrived.
And were you successful in stopping any of the bleeding before EMS arrived?
Partially, but from my observations, there was a lot of blood lost.
And how long would you say it took for EMS to arrive after your arrival?
Approximately 10 minutes.
When you got there, did anybody else from the Shelton Police Department arrive on scene prior to EMS's arrival?
I believe Officer Nemhard, or right around the same time. as
And
EMS.
at the point where you and Nebhard were on scene, what were your responsibilities at that point?
First of all, to just secure the scene, make sure we identified all the victims, number one, and also if there were still suspects in the area or on scene, as well as in the house, which we had not cleared yet. So just a lot of moving parts and identifying what was going on.
Just want to go through these exhibits a little bit. Stage 3, this is just another angle looking towards the street of Laurel Glenn that night. Does that reflect what the area looked like, minus maybe the headlights of the cruiser there?
Yes.
Okay. And again, Stage 4, another angle of 43 Laurel Glen in the area where you responded to. Is this an accurate depiction of what that area looked like?
Yes.
And 6, Stage 6, again, this is another perspective of that area on or about May 15th of 2022.
Yes.
And again, Stage 8, a closer up perspective of the area where you responded to and found 4 individuals suffering from stab wounds that night, excuse me.
Yes.
And again, Stage 9, this is the area from the left side of 42 Laurel Glen, the area you responded to.
Yes.
Now, after police responded to the scene and EMS finally responded 10 minutes later, did your responsibilities change at the scene?
Not at the time. I still assisted EMS in providing medical attention. Like I mentioned before, with whatever cloth or rag I was provided, I kept compressing on the wound while EMS then began doing compressions, as well as with the assistance of a neighbor, I believe.
And during your time providing aid with EMS, how long would you say you stayed with the fourth individual at that point?
Approximately 10 minutes.
And at some point after 10 minutes, what happened after that?
EMS then transported him.
And did you follow EMS to where they were transporting him?
I did not. I stayed on scene.
Now, when the individuals were starting to be transported, withdrawn, at some point in time, were the other individuals who were suffering from wounds transported to the hospital? Do you have?
Yes.
And did your responsibilities at that point change once those individuals left 43 Laurel Glen?
Yes.
And what was your responsibility at that point?
At that point was to secure the rest of the scene and contain the large amount of juveniles that were there so then we can begin interviews.
And did you in fact begin interviews at the scene?
Yes, I did conduct a few interviews.
And the information that you received from those individuals, did you pass that information on to anybody?
Yes, it was all passed along to the Detective Bureau.
And did the Detective Bureau, based on your observations, respond to 43 Laurel Glen that night?
Yes.
And who responded to that scene at that time?
Detective Bango responded, as well as Lieutenant Kozlowski.
And at that point in time, in May 15th of 2022, did you have body-worn camera?
No,
Why not?
they were not issued to us yet.
Okay. And at some point in time later on in that year, was body-worn camera a requirement of all police departments?
Yes.
Was it a requirement of the Shelton Police Department on or about July 1?
Yes.
So do you know whether or not the Shelton Police Department in fact had a body camera at that point in time?
I believe they had one body camera issued.
And do you know what, if anything, that body camera was used for in relation to any investigation?
I believe it was used to record some of the interviews.
And do you know, in fact, whether or not that body camera was used in this case?
I believe so.
Now, how long would you say that you were on scene at 43 Laurel Glen conducting your witness interviews and securing the scene for?
Approximately three or 4 hours.
And at some point in time, did you leave the scene?
Yes, I went back to the headquarters to type my report.
And based on your witness interviews at 43 Laurel Glen, not telling us what they said, but were you able to identify or develop a suspect that you were looking for from those interviews?
Yes, we were able to develop a group of suspects that fled in a vehicle from the scene.
And were you able to develop and identify a vehicle that they were seen fleeing?
Yes, I believe it was identified as a Honda SUV.
And was that information passed along to the Detective Bureau as well?
Yes.
They may have a moment, Your Honor. Your Honor, I have no further questions for this witness.
Attorney Smith?
Thank you, Your Honor. Good morning, Officer Blackwell.
Morning.
Just want to go over your testimony here. You are currently training, but you haven't yet started with the Department of Homeland Security. Is that true?
I'm employed right now. I'm awaiting to go to my training.
Okay. And where are you employed right now? Is that also with DHS?
Yes, with DHS.
Okay, but you are going to complete your training and then go on to do what exactly?
To be a Homeland Security investigator.
Gotcha. You told us that you arrived about midnight in response to a call from dispatch, correct?
Correct.
And you got to 43 Laurel Glenn Drive. That's a house in the Shelton neighborhood that you've described there on that Exhibit 1 behind you, correct?
Yes.
And that is a neighborhood that is comprised of a few through roads and then a number of roads that end in cul-de-sac. Is that fair to say?
Yes.
Were you familiar with this neighborhood yourself prior to going there?
To a degree, yes.
How were you familiar with it?
We switch assignments every day on areas that we patrol. So once or twice a week, I'd be assigned to that area.
You described that once you got to the scene, it was fairly well lit due to the vehicles that were there, people using their own flashlights, your flashlight, your
Yes.
car, correct?
Correct.
As you were driving there, is it well lit along that path from Adams?
On the road?
On the road.
I couldn't say I had headlights, obviously. I'm not super familiar with the street. There's street lights.
Would you say that it got lighter once you got to the scene than it was as you were driving there?
Yeah.
When you arrived, there were cars parked in the driveway.
Yes.
There were cars parked in the road, correct?
I believe so.
Both sides of the road, correct?
I believe so.
And you, in fact, didn't park there at the house. You parked some distance away and walked to the scene, correct?
Correct.
When you got there, did you notice that there were any signs of drinking?
Initially, no. When I initially, no.
When you say initially, no. At some point, though, you did come to see that there were signs of drinking having gone on at that location, correct?
Yes, later on in the night.
And what signs of drinking did you encounter?
I believe there was alcohol bottles found.
Was that inside the house, outside the house?
I can't recall.
Red Solo cups, kegs, bottles of liquor? What are we talking about?
I can't recall exactly.
all of that perhaps?
Possibly.
Objection as to possibly, I mean,
Overruled.
Were there any signs of any adults on scene?
Initially, no, but some adults did respond.
So when you initially arrived, do you think there were maybe 30 people there in the yard?
My best guess was about 30.
All juveniles?
Yes.
And do you think it's possible that there were in fact more than the 30 that you saw? Were others in the house?
objection.
Sustained.
Possible, yes.
Has that be stricken?
The objection was sustained. I'll move to strike. Ladies and gentlemen, striking the response, so you're not to consider that as evidence. Thank you. Attorney Smith.
You believe you witnessed approximately 30 people in the yard,
Yes.
all juveniles?
Yes.
You told us at that point you had not cleared the house, correct?
Correct.
Did there come a time when you did clear the house?
Yes.
And were there more people inside the house?
I believe so.
How many people would you say?
I could not tell you.
You told us that you began doing some interviews after you'd secured the scene, correct?
Correct.
What was the time that you started those interviews, do you think?
Approximately 12:45.
So about 45 minutes after you arrived on scene, you think?
Approximately.
And you told us that you spoke to, I believe, 3 different people on scene?
Possibly more, correct? Yeah, around.
You only took interviews or statements from 3 of those, is that correct?
Yes.
But you may have spoken to more?
Yes.
You told us you came to learn some information that you passed along to the Detective Bureau, correct?
Correct.
And that was information regarding possible suspects, correct?
Correct.
And information regarding the vehicle that some folks claimed they were in, correct?
Correct.
Did you learn at any point of the existence of any video or recordings that people have made?
No, I was not aware.
Did you learn that any of the people that you had spoken to had been involved in fighting or attacking either Mr. Valle or any of the other folks that were there?
I learned there was a fight.
Did you learn that any of the folks that you spoke to were involved in that fight?
Yes.
When you were speaking with those individuals, did they show any signs of having been drinking?
Possibly.
Did you take any notes while you were doing your interviews or otherwise on the scene?
Yeah, I had a notepad, as well as a written statement form.
When you cleared the house, did you notice any signs of drinking inside the house?
I do not recall.
You're shown here on the Elmo some photographs from the scene. I just want to take a look at those. Showing you what has been marked as State's Exhibit 3. That's a full exhibit. You see that, sir?
Yes.
And in this photo that you're seeing here, there are cars parked on the street. You see those?
Yes.
Is that how it looked when you arrived on scene?
I believe so.
Did you take this photograph yourself?
No.
And you see that there's some tape there, correct?
Yes.
That's the tape that y'all used to secure the scene, right?
Yes.
I'm going to show you now what has been marked as State's Exhibit 9. See that same tape there, correct?
Correct.
Securing the scene.
Yes.
And those vehicles, those are the same vehicles that had been parked when you arrived the night before, correct?
I do not know.
Showing you now what has been marked as State's Exhibit 2. Do you see that, Officer Blackwell?
Yes.
Would you agree that those same vehicles are there in the parking, in the driveway?
As the previous picture,
As in the daylight picture that we just saw with the secure tape around it?
I would have to look side by side.
Sure. You see what I'm showing you right now is Exhibit 2, correct?
Correct.
You see those same vehicles there?
2 of them, yes.
can't see what was on the other side of those vehicles in the picture that was shown before. Is that fair to say?
Yes,
But you see that tape behind those vehicles, correct?
correct.
From your training and experience, that tape is meant to keep the scene as it is, correct?
Correct.
Did you use that tape? Did you put that up yourself?
I do not believe I did.
I'm showing you now what is State's Exhibit 2. Do you see that, sir?
Yes,
See that same tape that's corralling off the yard, right?
yes,
Because that was the scene of your investigation and you wanted to secure that, correct?
correct.
No tape used in the street, would you agree?
I do not recall.
Did you ever use any tape to secure any of the vehicles that were parked there on the road on either side?
I did not.
I'm showing you now State's Exhibit 4. Do you see that, sir?
Yes,
You see any tape that's in the street?
just on the basketball hoop.
Nothing in the street, however, correct?
No.
And would you agree, sir, that vehicles that had been there the night before are no longer there in this daytime picture?
Correct.
Officer Blackwell, fair to say you've been called here today to tell us about what you witnessed when you arrived on the scene, right?
Yes,
And you've done that to the best of your ability.
yes.
But if what these jurors want to know is why Mr. Valle did what he did that night, you can't really be of any help to them at all, can you?
No.
Nothing further.
Attorney Durso.
I have no further questions for this witness.
Oh,
Your
very
Honor.
good. So witness may step down. Thank you. Attorney Durso, I think this is a good time to take the morning recess, okay? So ladies and gentlemen of the jury, I did indicate that we would be having a morning recess as well as an afternoon recess. So we are going to stand in recess for 15 minutes and we'll be back. If you wouldn't mind, please leave your notebooks on the chair. And again, don't discuss anything about this case with your fellow jurors as we take that recess. Thank you. Court stands in recess for 15 minutes. May I see counsel? Thank you.
Court's in recess.